Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, everyone. You had an opportunity to reread if you didn't read it if you read it the first time. Unit 1. Have any questions? Silent gives consent. That means yes, no questions.
Not right now.
Okay, well, great. All right. Just don't be silent, because I'm waiting on an answer, because I don't want someone to come later and say, well, you didn't ask us if we had any questions. So,
No. At least
okay.
I can ask. If I don't understand, I will ask.
I know you always ask. So unit 2, did you read it?
I even ain't gonna lie to you. No, I didn't. I started, but I didn't finish.
That's fine. Anybody else? Always good to be honest.
I didn't have a chance to read it because initially I was not sent the link for the class or the course material. So
okay.
I kind of started in the class last Monday, very late. So, and I hadn't had a chance to see what the material was at that point. So I kind of didn't ask any questions because I really hadn't, had an opportunity.
Okay, that's fine.
Yeah, and I came in on, in the middle of the class, so I didn't want to disrupt the class.
That's fine. So you could read it if you have any questions by next Monday.
Okay.
You could let us know.
All right, thank you.
No, not a problem. And then, the classes, some people are in the area already. Some are trying to get in the area. Somewhere in it came out. And so it's a good opportunity if you have questions to just ask. It doesn't hurt to ask, no matter how silly you may think it is. It's okay. Now, I know you saw lots of emails coming in from Mr. Pratt.
Lots and lots.
Aha, yes. So you see, I was very busy. So over the different classes, we'll pick different ones. For tonight, I think we'll have an opportunity to look at, see if you could find the case of Raleigh Butler versus the McDonald and Island Acquisitions. See if you could find that one. Open that one and minimize it. Raleigh Butler.
Raymond McDonald. Merle McDonald.
Yeah. Okay. Minimize that one.
Excuse me, where is that found?
Look in the emails from Mr. Pratt today. He sent 4 emails.
I printed all of them.
Oh, very good.
Yeah,
Okay.
Look for that one.
That's a good costume.
And the second one is look for the case of Sandra Kemp and Therese Major. Sandra Kemp and Therese Major versus Mamlaka Limited.
Good evening. This is Keishla. I'm just joining. What is the first one we're looking for?
Raleigh Butler and Raymond McDonald.
Okay, thank you. Have it.
Okay.
All mine's in.
Hmm?
Hello?
What happened to yours?
All of my all of the cases being loaded. I don't know why.
Yeah, they should. They should. Let me know, because then I could send a message to Mr. Pratt and have him resend it. If you have any issues in opening it.
What's the first one again?
The first one is Raleigh Butler versus Raymond McDonald and Merrill McDonald and Island Acquisition.
I don't think I have the first one either with
You don't?
Raleigh Mac. No, I don't. I don't
He didn't
see
send.
it.
He should have. Raleigh Butler. He should have sent that one. But you have the other two.
I have Sandra Kemp and
Yes.
Therese Major. And then there's another email with a few attachments. One is the treasurer of the Bahamas and ALCO.
Yeah,
Effie
we'll do that one.
Knowles,
That's the next one.
Rumkey, Simon FB Rodan, and Strawn versus Strawn, common law and equity.
Okay, we'll stop at, so we have Raleigh Butler, Sandra Kemp, the treasurer and ALCO, and Effie Knowles saga. We'll start with those. Now the Effie Knowles saga is a story you have to read. What was the other one you said you saw? So I can pull that one up.
Bank of the Bahamas versus Christensen.
No, we won't do that one tonight.
Okay, so I clearly I'm missing something. I'm not sure how he would have sent it, but
Everybody, I think he sent 4 emails. He sent 4 emails.
I don't know them.
Rob, none?
No, but I have a few here, but I don't see the two dealing with tonight.
Let me go to my email. I'm copied, so let me see. Hold on, give me 1 second. Let me go to mine. Let me go to mine. Hold on. Here. Whenever you want something, the internet plays with my mind. It's taking a while. Okay, it's coming up now. Okay, so the first one, he says, cost materials 1 of 4. You have that email sent at 2:37. And that's the one of James F. Walker versus Susan Lundberg. You see that one?
Yeah, I see that one.
Okay, all right.
You said he sent that at 2:37?
Yes.
Okay, I don't have that. I have, is that the one that says 2 of 4 emails?
No, 1 of 4.
Okay, I don't have the 1 of 4 emails.
Hold on, let me forward it to you. Give me your email.
It's SMICHEL.
M-I,
S as in Simone.
huh?
You say our 3 times too?
You want me to send it to SMICHEL at BMC, B as in boy, M as in man, C as in cat, homes.com.
At B-A-C.
BMC.
Why isn't it coming up?
Let me send it to you in the chat and then you can capture it better like that. I sent it to you actually the other night.
Oh, it's here.
Right.
He sent it to you. He sent SMICHEL at BMCHOMES.com.
It's BMChomes.com, yeah.
Yeah, he did. Look in your junk, see if it's in there.
Okay, I looked in my junk. And you said he sent that at 2:37. I have an email from him. One says that use this new link. One says course materials 2 of 4.
No, you're
One
missing
says
4.
course materials 3 of 4. So I'm missing 1 of 4.
Yeah, but how come? But it's here.
And I see 4 of 4.
SMICHEL at BMCHOMES.com.
Yeah.
Okay, tell me if you get it.
Okay, let me see.
It's coming.
Yeah, good. So sorry, it's good. I get over here, folks. Somebody didn't get all the materials.
Yeah, she missing the first one. I'm trying to see. Her
Oh,
name is
email 1 of 4.
Yeah.
Yes.
Okay, who's missing that one?
Simone Dillett Michelle.
Okay. Let me resend it to you. Maybe that was the biggest one. That was 11 megabytes.
No, that's only James versus a small.
James Walker versus London
Yeah.
Grad.
Yeah. So
did you Mr. Pratt,
I go to my emails now and double check.
Okay. If you send it to the Gmail, I'll check the Gmail. Maybe like you said, it's too big or something.
That one is not that big. I mean, it's a couple of good pages, but not that big. There's one that's really big. There's one that's 116 pages, but it gives you some really good information.
Okay, Mr. Archer, I just got yours.
Okay, so you don't need to. Oh, Miguel, you don't. Yes, that.
All right.
Yes, that one.
All
so
right.
Then you have 2 of 4, 3 of 4, and 4 of 4. So you won't be able to do all of them tonight, but we'll start with a few of them. So let me know if you have the 4 emails from Mr. Pratt.
I think something's going on with the Outlook that we have because now it's saying not responding.
Oh God, it's wasting me just now. I was trying to send it to you.
That's crazy.
Everybody else has all of the emails, right?
Yes, I do.
Okay. All right. Let me look at the 204. This one is. When's this bite? Oh, come on. Okay, so let's get started on the module. And then as we get to different sections, we look at some of the cases. So in the last class, we spoke about when someone wants to purchase property, the way in which you go about it is you have to enter into a contract that's called an agreement for sale. And the first thing you have to look at is when you purchase property, like we were saying on Monday, it's all about investing. And when you invest in property, like I said on Monday, you acquire an interest in that land. And once you're dealing with property that is covered under the Conveyancing and the Law of Property Act 1909. And it depends on how you actually going to go about in purchasing the property in terms of whether or not you're going to the court to quiet that property, which is called adverse possession, or you actually just going to purchase it from a vendor or seller, and your attorney will then go through and look at the title and actually do their research to see whether or not the title is a good title. Remember, I said it's 30 years or the certificate of title or a crown land lease. So the first thing you have to do is you have to prepare the contract. And the contract means it's like any contract, which means that there is an offer, acceptance, you agree, and of course, consideration, which is the deposit that you're going to make. You're going to agree on a full figure, but you're going to make a deposit. And it says that both parties must have the intention to create legal relations. That's what that word agreement means. So the first step in purchasing a piece of property is to come to an agreement. And that agreement is what you call your contract for sale between vendor and purchaser. The terms of those contracts are negotiated between the two parties, even though most of them are standard. They could also be done along with the real estate agent, or the parties' attorneys can actually have the vendor draft it and the purchase attorney review it and see if there are any changes to be made or any questions or clarifications required. The agreement for sale should outline first the purchase price. Of course, it would have the names of both parties, but it would have the purchase price, the deposit that's going to be paid, the completion date, that the vendor has to prove good and marketable title. And then it would stipulate the undertakings of the vendor and the purchaser, the obligations on both, in order for the agreement to actually be executed. And then, of course, the consequences if the vendor can't prove good title or the purchaser is not able to provide financing or just simply can't complete the transaction. So that agreement for sale, that contract, should cover all of those elements. The next step is the exchange of the contracts. The deposit is normally 10% of the total purchase price and is normally paid to the vendor's attorney and is held in escrow. The next step is deducing title. So after they would have executed the agreement, so both parties have signed, the deposit is paid, the attorney has it held in escrow. The vendor then provides the receipt of the original and or the copies of the title documents. And this abstract of title covers a period of time fixed by the contract. So once that is received, of course, you know, the purchaser's attorney is going to start asking questions. So normally before you exchange that contract, sometimes you would ask the vendor to deduce the title. You want to see whether or not his title is actually good title. Now, some people do it after the contract is signed and they paid the deposit. But if you are wise, before you make your deposit, you should ask to see that title, to see how did they arrive at their title, to know whether or not you're going to end up with a good title before you make your deposit. So once you have executed the agreement, you have your abstract of the title. You either get it before or you get it after. Then it's time for you to have your attorney conduct the investigation of the title. And they do this by going through a search of every one of the actions that is listed on the title, and also going through all of the judgment in the Supreme Court to ensure that there's no judgment against that property by any of the previous owners, if they had any judgments. And you also look to see if there's any judgment against the vendor himself, because the vendor may actually have a judgment in which the property is the security and that has to be sold. So under the act, a purchaser of land is not entitled to require title to be deduced for a period of not more than 30 years. Or they take it back, like I said, to a grant or a lease by the Crown, or the third option, of course, is a certificate of title, and which comes from the Quieting of Titles Act. And whichever one of those three periods is shorter, that is as far as you go for a root title. The purchaser's attorney can also investigate any outstanding real property taxes that have been levied on the property. Or if there's any outstanding association fees or dues, any utility that's outstanding. And if it is by a purchase is by a non-Bahamian, of course, you have to make sure that applications have been made to the investment board for permits. The purchaser's attorney can also raise requisitions. And requisitions means that they can ask questions on the title or any other matter that relates to the seller with the seller himself or with his attorneys. The purchaser could also reserve the right to raise further questions later down on the title. And he could also include that provision within the actual agreement for sale. So like any contract, most actions or most matters that require an action on behalf of either the vendor or seller always has a time period, because you would never leave a contract that's open. You never say, well, you can request documents such as, but you don't give a period, because that means that the contract can stay open for a very long time. So with a contract for sale, because you're purchasing land, you want to follow a set time period. So normally the agreement for sale provides for a specified time period, and that's like 14 days from the receipt of the title document for any requisitions to be made. by the purchaser's attorney after investigating the title. Now, in addition to requisitions on the title itself, the purchaser's attorney could raise questions on the requisite government and subdivision approvals. He can ask about outstanding real property tax assessments and utilities. He can also ask about the survey of the property and also whether there's any easements and right-of-way or restrictive covenants. Now, once he is satisfied that all the requisitions are being responded to, the purchaser's attorney can then prepare a report on the opinion of title for the purchaser and or any relevant lending institution if it's a bank. The draft conveyance is then prepared by the vendor's attorney. And this could be reviewed at the same time when you're actually looking at the requisitioning of the title. The conveyance will normally include the name and addresses of the parties, any references to earlier title document, a detailed description of the property, whether again there's any restrictive covenants or easements or rights of way. It includes a plan of the property, the appropriate affidavits of citizenship, a witness, and any other relevant information for the conveyance. So you see why the cost for doing this justifies. This is a lot of work. So once completed, amended, and approved, because you know, after the vendor has prepared it, he's going to send it to the purchase attorney who's going to review it and send it back if there are corrections that needed. So once that is done, the conveyance is finalized by the vendor's attorney and is executed by the vendor and the purchaser. And of course, the signatures are witnessed. A completion statement is then prepared by the vendor's attorney, and the balance of the purchase price is paid by the purchaser's attorney or the purchaser himself. Less, of course, the vendor's portion of stamp duty and any real property assessments and utilities or any outstandings. That's what they're called, any outstandings. The vendor's attorney may forward the title documents to the purchaser's attorney in escrow, pending the final payment. The legal fees will range between 1.5% to 2.5%, and they're paid on or before the completion by the vendor and the purchaser. Commissions to real estate agents are also paid at that time. Any requisitions for utility companies to return deposit to the vendor and any utilities and real property tax assessments are placed in the purchaser's name. So once the balance of the purchase price is paid to the vendor's attorney, subject of course to the completion statement, and the vendor attorney acknowledges receipt of payment, the property transaction is complete. The conveyance then that the purchaser has, along with any appropriate affidavit or documents, is then sent for stamping at the public treasury. And the stamp duty is to be paid on a conveyance, which is normally split between the vendor and the purchaser, and is based upon the total consideration or purchase price of the property. And you'll see further down that there are certain conditions when it comes to paying taxes on property. But sometimes under the VAT rules, the VAT controller can look not at the price or the consideration in the contract, but they have the authority for you to request an appraisal of the property to assess if you're paying the correct amount of taxes to the government. Any questions so far? No?
No, ma'am.
Okay.
No, ma'am.
All right. So the next step after this is the purchase of property by non-Bahamians. So non-Bahamians are allowed to purchase property in the Bahamas, and some non-Bahamian property investors do this through an IBC. So, you know, we have the IBC, which is a Bahamian company, and that was actually designed for international business, not just for holding property, but it's really a product that is used for wealth management and asset protection. So you will have a lot of international persons incorporating an IBC, and they use it to hold property. And what it does is it allows them, it gives them anonymity because their name is nowhere on the face of the documents. Because it is an actual company, they have limited liability. The company is a separate legal entity. It has perpetual succession. And of course, it has it's confidential because most of the of the actual beneficial owners of these IBCs. So a non-Bahamian is required under the International Persons Landholding Act to register their purchase with the BIA. And then they obtain a certificate of registration. Otherwise, they are required a permit from the investment board, and that's prior to their purchase. A certificate of registration is not only required for vacant and non-vacant land, but also for condominiums or property under 2 acres that will be used as an owner-occupied property. A permit is required by non-Bahamian property owners for the purchase of property that is 2 or more contiguous acres to rent out all or portion of the property, or where the property will be used for a commercial purpose, such as rental and resort development. So in that instance, they have to obtain a permit for any subsequent purchase of property. Permanent residents, of course, have to register a purchase of real property. A non-Bahamian lender that acquires security or properties in the Bahamas require exchange control approval from the central bank and a permit from the BI, from the Bahamas Investment Board. So I want you to look at that document in your list called the Effie Knowles Saga. And I don't want to tell me if this raises, based upon what we've just finished saying about agreement for sale, and also about what's required for non-Bahamians. I'm just going to highlight a little bit of it, and then you can read it on your own. So this is a story about unusual Bahamian connections, a tale that begins in the 18th century and still spins today. It's a story about Indians, lawyers, and land sharks, and a glimpse of the life of one little-known woman of Bahamian descent who made good in the United States, but left open a Pandora's box of island intrigue. Florida lawyer Effie Knowles is something of celebrity in Bahamian real estate and legal circles these days, although she has been dead for 20 years and few people have ever heard of her. Anyone heard of her before?
No, ma'am.
No.
I haven't.
Come on, y'all have to know your history.
I really never ever this in school.
Well, I wouldn't even go to the school part because I don't know. They don't be teaching it. Okay, so her parents were Bahamian immigrants, like immigrants. She was born in Key West. She died in Miami in 1984, which was recent, at the ripe old age of 92. Her grandfather was James Alexander Knowles, was born on Long Island in 1839, and he moved to Key West. Florida did not become a U.S. territory until 1821, and for a long time, Bahamians looked on the Keys as Northern Out Islands. At the end of the Depression, the 1930 census puts Effie living with her widowed mother and her two sisters and a brother in Miami. And all five were described as white and literate. And Effie, a lawyer, owned the house. They're all now dead, but their legacy lives on. In fact, Effie's claim to more than 12,000 acres on several Bahamian islands has generated enormous controversy, lately with some describing transactions involving this estate as the biggest land fraud in our history. Effie's mother, Julia Dossett, was from Nassau, where both of her parents were born. Julia went to Key West as a child and married William Knowles, an American, whose father was from Long Island. When Julia died in 1956 at the age of 91, the Miami Herald described her as a Florida pioneer. Effie's father died in 1904 in Key West, but his great-great-grandfather was James Knowles Sr., another prominent loyalist planter who received extensive crown grants on Long Island before his death in 1805. So on the mother's side, Effie's grandparents were Laura Nairn and Joseph B. Dossett, a salt raker on Rum Key. Joseph's grandfather was George Dossett, a privateer from Charleston, South Carolina, who died in 1783 after receiving land grants in the southern Bahamas. So the properties were on Long Island, Eleuthera, Rum Key, Andros, and Cat Island, as well as dozen prime lots on New Providence. And all those are subject to intense dispute among attorneys, realtors, developers, and buyers. And they're involved in court cases in Florida and the Bahamas. So since Effie nor her father were Bahamian citizens, experts say she may well have forfeited any land claims simply by failing to pay property taxes. According to local lawyer Bill Holowesco, the origin of Effie's estate dates to the 1960s, when Holowesco worked for H.G. Christie. Any of them names sound familiar to you?
Yeah.
Okay.
Yeah. Oh, so.
And
Yes.
H.G. Christie.
H.G. Christie.
So he said, Effie came in one day with a list of properties around the country that she claimed to own, he said recently. She had gone to the registry and simply copied all the crown grants of people in her family tree. This list keeps reappearing. There is no doubt about the crown grants, but lots of things could have happened along the way, Holowesco added. I told H.G. Christie that she didn't own a lot of this land, and he never agreed to buy anything. And all of this controversy is rich with irony in view of Effie's efforts over many years to reclaim Florida land for the Seminole Indians. So we don't need to read that part. That ain't nothing to do with our land. But apparently she won a suit for the Indians, and they were awarded $12.5 million for 32 acres of land. And she was paid out of that a fee of $150,000. So she had all of this land that she claimed as hers. So in 1987, Soon after the will was probated, the McDonald father and son team sold Effie's property to a Bahamian company called Newport Harbor Limited, set up by Bill Davis, a former state senator from Arizona, through Nassau lawyer Dawson Roberts. The price was only $180,000 for thousands of acres on several islands. But Davis failed to get government approval to complete the transfer. So some say the land reverted to Mr. Roberts, although the title remains questionable. According to one expert who has seen the documents, Effie Knowles probably had as good a title as anyone to these properties under the circumstances, but it could just as easily be challenged. In the meantime, the McDonalds began reselling their estate. Many of these transactions started out with conveyances for large chunks of land at nominal prices, which the Bahamian government accepted, although realtors say the land was grossly undervalued, assuming good title. For example, just 2 years ago, the McDonalds conveyed 2,000 acres at Rumkey for $128,000 or $64 per acre. 1 acre lots on the water at Rumkey are now selling for $250,000. And this property, together with everything else that Effie Knowles owned in the Bahamas, has ostensibly already been sold to Newport Harbor. So in 2004, Newport Harbor filed a writ against the McDonalds for allegedly fraudulent conveyance of land, legally and beneficially owned by the company. But the sales continued as the luxury property market in the Bahamas heated up. One of those the McDonalds resold land to was Rumkey Ventures, owned by Americans Michael Fothergill and Steve Swatzer. Fothergill was convicted of money laundering and bank fraud in Florida in 2002. His company has been reselling lots to foreign investors who may not be aware that the titles are questionable. And there have been many conflicting claims to other parts of the estate. According to realtor and former member of parliament Mike Lightburn, the Effie Knowles saga will go down as one of the biggest land frauds in Bahamian history. I have never experienced anything like this in my life, where land can be marketed all over the world on the internet and foreign buyers pay an overseas attorney to buy something for which there is no title. And for a woman who played such a key role in settling historic Indian land claims in Florida, the disputed status of Effie's sometime Bahamian estate is a fascinating tale of genealogy, greed, intrigue, and government incompetence. Any comments? And attach are the maps.
How can they sell land? that is owned by someone else, who is owned by someone else that is in court.
It's called, called fraud.
That happens every day.
Yes. And I notice now, you notice when you go on the family islands, except for generation property, and you notice a lot of properties are owned by foreigners. If you go to Long Island on the southern part of Long Island, when I went there last year, I saw these huge stands like billboards all on the eastern side of South Long Island.
Mm-hmm.
Name of a foreign company. Do not trespass. Do not trespass. Another name of the company, a foreign company. And I'm driving from pole to pole to pole to pole. I say, well, how did they acquire this land?
Through fraud.
And when you sit down tonight, you read this or you read the story again and you try to digest this, you could see from this what this woman did was she went back to all of this. You went back to all of your grandparents and great grandparents all by name. And then you go to the registry to see where they were granted land. And then you claim you own it.
But Ms.
Not
Archer, that
checking to see
happens,
where the-
that happens locally very easily. For instance, if there's someone living on a lot of land in a house and they have a vacant piece of property next to them, they know that the property does not belong to them, and they even know who the owner is, who may be away somewhere or whatever. And what they do is they begin occupying the property by planting a banana tree here and there and doing different things to it. And eventually what they do is they just go and petition and say that the land belongs to them.
Okay, so hold on now. As something else, we'll dig in a little bit. Even though like each chapter is on a particular topic, I like to carry the conversation on these things so you can get a good understanding. What you're talking about has two faces to it. That is not illegal. That's the first thing. You can actually do that and bring your claim under the Quieting of Titles Act. You can. I have cases on that too, right? But what lawyers are saying is that they said that act perpetuates fraud.
Exactly.
So it has two faces. And if you look in your documents, there's one there called Bannerman Town Millers and Eleuthera Association. It's called the Quieting Titles Act and Bannerman Town Eleuthera. It's very long, 116 pages. That is on quieting of titles. That should be in your documents from Mr. Pratt.
Yes, I see that. I have that.
Okay, that's a good read. But that part, what you're saying right now, that is legal. If you look in the paper, you see the notices, right? You see
I
the
don't
notice.
think it should be, I don't think it should be legal though.
The thing about it is, if the citizenry doesn't protest, then things go on as normal. That's how it is. But it is legal. And that's how people claim their title. Because what you do is you put in your petition and then you put your legal notice in the paper.
Hmm.
And you actually state that you are the if you take something like, let's say that one of these old people actually did own this property. Most of the times they may have had one child or maybe none. No one is around. They do their research and then they take it. And that's how they're getting land for little or nothing. But I agree with you. But that's a good one to read. We'll discuss that one later down on one of the classes. So that's the Effie Noel saga. And you notice the company that claims that they purchased the land was out there on the international market reselling that land. So imagine the people who purchased the land. They're also out there and resold it to someone else who now probably get board stuck up on the land and saying that it's theirs, but they do not have good title. They don't. Okay, look at the case of Raleigh Butler. and McDonald's. Now you know in the Bahamas, our court system, the hierarchy of our court systems. So you know you have the administrative courts. That's the coroner's court, the gun court, those small courts.
I think this is the one that I didn't get. I didn't see it in any of the attachments.
But then
The
I said
Raleigh
it-
Butler one.
No?
It said James
Oh, you
James Walker.
let me see if it's in this one here. Petition or no. Hold on, let me see. I'm clicking another one. Let me see if this is it. Yeah, look in. I can tell you right now. Look in the email. Where is it? 204? No. Not
204 is Commonwealth Whims, right?
No,
And Miller's.
304.
Bank of the Bahamas.
The next one.
Common Law Equity.
Next one. That's Raleigh Butler.
Okay, yeah.
Okay, all right. So like I was saying, our court structure, you know, we have the administrative courts, and then you have the magistrates court, the Supreme Court, the Court of Appeal, and the Privy Council. So sometimes the cases, what I will send you will be from the Supreme Court. Some of them are appeals to the Court of Appeal, and some of them are appeals to the Privy Council. So in some instances, if you really want to get all of the discussion that was held, sometimes you have to start at the first court. But this one here is at the Supreme Court. And in this one here, the defendants who are the McDonald and this company Island Acquisition and Jorge, they were, an injunction was filed until judgment was made in the action. And so they had an order from selling, advertising for sale, subdividing, trespassing, interfering, excavating, or dealing with the tracts or parcels or lots of land situated on the island of Rum Cay. So by the same order, the defendants were given leave to apply to discharge this injunction because they wanted to go ahead and sell it.
Rum Cay is a hot island.
You see that, right? That's so small.
Exactly.
So the defendants contend that the third defendant, that's the company, Island Acquisitions, they say that Island Acquisition had a good and marketable title based on their documentary and possessory title. And whilst it accepts that the land, the subject of the action with reference to the third defendant, the Fraser tract was originally conveyed to a predecessor in title of the plaintiff as a tenant in common, any interests of Raleigh Butler and his family was extinguished, right, by adverse possession. Adverse possession is quieting title. Remember what I said? What's the three options you have where you stop for root title? What did I say? 30 years or adverse possession as quieting of title, or crown land lease. Those are your three options for root title. So they say that the company Island Acquisition, their title to the land begins with a warranty deed. And that warranty deed was dated June 1st, 1964. From Beatrice Knowles, Laura Knowles Roberts, and William D. Knowles. Do they sound familiar to you? Any of those names?
Isn't that the family of Effie Knowles, maybe?
Well, of course it is. Go to your SIGA document. You see where the little asterisks are? The paragraph after that says Florida lawyer. And then it says her parents. And when you go down, it says Effie living with her widowed mother, Julia, her two sisters, Laura and Beatrice, and a brother, William. And all, listen now, they say all said to be devisees under the will of the late Percival R.S. Dorset. Sound familiar again?
Yes.
Okay, so when they say devisee under the will, they mean that under the will of Mr. Dorset, he left these properties to these persons named here. Say, unfortunately, neither a will or grant of probate of the will of Mr. Dorset has been produced. So that's the first strike against you. Because if you're looking at, if you're trying to get root title, and one of the steps was that there was a will, and in the will, it divides the property to these three persons. Then you, next document you look for is what? The deed of assent. So further in the schedule to the warranty, the claim to the property in Rumpke by the grantors in the warranty deed is based on possession of the property by the said Percival R.S. Dorset from 1897. So following the grant of the warranty deed, the defendants allege that the late Effie Knowles, you know that woman, exercised acts of dominion and entered into actual possession of the property. One of these acts of dominion was set out as a lease from the late Mrs. Knowles to Rumpke Development Company Limited on May 4th, 1967. So put all that paragraph in English. What is it telling you?
It tells you that she acted as the person with ownership of the property and was acknowledged as the owner, and she entered into a contract.
So the property didn't belong to her.
No, she has purported. When you read the saga, she has purported. Okay, don't forget now, when you say you own a piece of land, you have to produce a possessory document. And that possessory document is your conveyance, right? But when you talk about getting root title, you have to prove one of those three options. This is not hearsay. You actually have to be able to follow the steps to one of those three options. So if the will cannot be produced, how can you prove that these three persons were left this piece of land by Mr. Percival Dorset?
Conveyance?
No, if he left this to them, you need a deed of, not a conveyance. You only have a conveyance when you sell. When someone leaves something for you in a will, you get a deed of assent. Now, after you have the deed of assent, if you want to sell it, you have an agreement for sale and you have a conveyance.
A deed of assent.
That's what you call the document when in a will, they say, I devise my property on Blue Hill Road, lot number 125B, situated on the corners of so-and-so to my daughter, Eloise Marie Smith.
Okay.
To transfer that to Eloise, she needs a deed of assent.
Okay.
Because don't forget now, the conveyance is already there in the name of the person who's leaving it to you.
Okay,
Deed of assent shows that you are now the owner of that document. Now, if you want to sell, you have to go and enter in an agreement for sale,
mm,
the conveyance. And then the conveyance will be from you to the purchaser.
to the purchaser.
Right. But in order for you to do that, you need a deed of assent because it was given to you in the will. It says in paragraph 7, this document is very interesting. This warranty deed, because it clearly shows that the parties were not convinced of the good title now being touted by Island Acquisition. Say indeed, the lease clearly states that whereas it is necessary and desirable that appropriate proceedings be instituted to said real in order that it may be made readily marketable. And in this connection, it is necessary that field surveys and inspections be made. So just by the wording, you knew that there is some doubt as to whether the vendor has a good title. It says the grant will proceed with diligence to survey, plot, initiate, prosecute an action, quiet title to all of the property indicated on the plot, or so much thereof as may prove to be expedient in light of the conflicting claims. So just by the paragraph itself in the warranty, it says that in order for us to proceed, we have to ensure that we have good title to the property. And if that means that we have to quiet, then that is what they're going to do, because they're going to see exactly how did they obtain their title. So the defendants also claim that the company was what you call a purchaser for value without notice of any claim by the plaintiff. So Riley Butler is saying that he owns the property. He has a claim against that property. And what they're saying that the company was not aware of his interest in the land. But the court is saying that once you would have read those 2 paragraphs, any prudent man, that means anybody on the street, would say, hold on. This person may not have a good title. So Riley Butler then comes and he produces with some documents, affidavits to support his claim that he has inherited a portion of that land. And he's also representing other owners. The documents he's showing on their face, it show a clear line of title from the conveyance to the first Myla Butler and John Culmer to the plaintiff and other members of the Butler family. Now you see the controversy? He has a conveyance from the first Myla Butler and John Culmer to him and other members of the Butler family. And then he has affidavits which show occupation of the land by the Butler family from the time of the conveyance to the present. So the court said that based on the evidence before them, there are issues to be tried between the parties. And so the defendant requests to have the action dismissed as abuse of process. The judge says he does not concede to that application. And then they wanted the injunction lifted so they could go ahead and sell and market the property. And he says, it is alleged that the plaintiff and his predecessors in title were dispossessed or abandoned possession, and that there was possession, dominion, and ownership by Effie Knowles and the other predecessors in title of the defendants. So you see what they've come back with now. In their affidavit to the court, they're saying that the company was a bona fide purchaser for value without notice. They were not aware that Raleigh Butler had any interest in this property. And he's saying that even if he had interest in this property, which was the conveyance to the first Myla Butler, and then the conveyance onto him and other family members, they're saying that they would dispossess or abandon possession. And it was taken over by Effie Knowles. And then they also told the court that the company has already spent money preparing the land for a subdivision and tractors. And by having the injunction on them, they are losing money. But they didn't produce to the court any subdivision approval. And he says here on paragraph 15, I know that several lots are being sold. And if the company should not succeed in this action, these sales and subsequent sales, should the injunction be lifted, could result in negative publicity for the Bahamas. So this is the company now telling the judge that he got to look at all sides of the coin. Because if Raleigh Butler is allowed to say he has an interest in the property, then that means that the property that was sold by the company is going to affect the reputation of the Bahamas. So the judge said, because of the matters at stake and the delay already having taken place, she would order that the defense be filed within 21 days and that the plaintiff proceed to have the action progress in a timeliest matter. So now I need to go and have a look from 2007 to now. I did last night. I did 2008, 9, 10, and there are no judgments in the Supreme Court website to see what happened after. Because as you can see, this is connected to the Effie Knowles saga. When you're talking about Rumkey, the Butler and the Dorset family, who claim that that property is generation property. But Effie, on the other hand, says that she owns those property from her father or her great-great-grandfather. So that means somewhere along the line, if you look at the documents that Raleigh Butler holds, it means some member of her family, if it was her family, sold property to the Butlers. Any comments?
I'm trying to digest everything that I have already heard.
Okay, go ahead, go ahead.
This seems to be a real confusing case because everybody seems to have claim to this estate of property, more or less.
Mhm.
There seems to be no starting point to say, well, Miss Christine actually owned it and then willed it or gave it to Tony Simmons, and Tony Simmons willed it and gave it to Michelle Mills, and like they say, paper trail.
Yeah, no, there is not. There is not. You see, the tricky part of this is Effie Knowles has built or constructed her genealogy. When you read, if you were to draw her family tree, you will see she went all the way back to the 1700s. All the way back to her great grandfather being here in the Bahamas and saying he was awarded these lands. So if you look at Raleigh Butler's claim, a member of his family could have purchased a piece of property, either legitimately from her family or legitimately from someone else who say they own the property.
Exactly.
So I think to do this, and again, this comes read more of these cases, you begin to guess what? Rumpke is very small. Tell me why someone could not take this to the team of 5 to 10 people and start from the very beginning of all of the documents that were left there from the colonial days and trace each piece of property on Rumpke. And ownership would rest with the documents that can be found.
That can be found, exactly.
But you'll notice when you read these things, everything is up in the air. I say I own it, you say you own it.
You say you own it, exactly.
You bring your
Everybody
documents
own it.
my 3 months. Which one sound better? So now you have this woman purporting to own all this property. She's dead now. So when you ride around to these out islands and you see all of these vacant land, and you wonder, well, wonder who own it? Must be generation property. No, foreigners claim they own it. And then you have foreign attorneys or foreign realtors who are going around and selling property in the Bahamas.
But then to Ms. Archer, this goes back to the beginning of our class when you said no proper recording of land registration.
Exactly. And you read more and more cases, you realize fighting of title and adverse possession is the way in which people steal other people's land. Because if you've done your work properly and you've done your research, you know, so guess what? No one really have good title to this land. But I don't need 12,000 acres. I don't even need 100 acres. I can take half an acre.
So in this case throughout, it means that there was never a proper title search in any of those transactions that took place, whether the Butlers purchased their property from an actual family member that owned it, or, you know, the title company did whatever. Clearly, whoever was supposed to be doing the searching didn't do a proper job of that, or maybe didn't do it at all. Because like you said, you're supposed to go back at least 30 years, or, you know, if there's some other transaction, whichever is the lesser of the two. But I mean, it seems like there were so many different transactions that happened, and yet nobody, you know, realized or came upon the information to realize that, okay, something is wrong here. This isn't okay.
No, they didn't think of that. And that's the problem we have with this unregistered land. That is the problem. And so you have to be very careful, even when people come, and you notice why a lot of the banks are not inclined to grant mortgages on the family islands. Because you had the same problem with some areas in Nassau. People were selling properties that they didn't know. And it's very dangerous. I'm giving you lots of food for thought, hey.
Yes, you are.
You're making us all very depressed. That's why we're so quiet.
Why are you depressed? Why?
All of this is very disheartening.
No, I want you to rise up. Education is key. If you didn't take this class, you would have never known.
That is so true.
Okay, so somewhere in your thing, you have a document entitled Rumpke Scam, Master 13 years in. See that?
Yeah.
So the mastermind behind an $8.3 million scam centered on Bahamian real estate was this week sentenced to almost 13 years in prison. The judge branding the fraud perpetrated on more than 100 investors as exceptional. Lawrence Foster, whose Paradise is Mine company, fraudulently promised international investors that it was developing land on Rumpke, received a 152-month sentence from a South Florida judge following his conviction by a jury trial on 8 counts. The Tribune revealed last October how Foster was convicted despite numerous Bahamian attorneys testifying at the trial in Miami that he and Paradise's Mine had good title to the Rumpke real estate they were purporting to sell. You hear what I just said?
They got some good money, eh?
Judge Donald Graham, in a ruling this Monday, threw out Foster's bid to reduce both the length of his sentence and the loss suffered by those he defrauded, finding there was substantial evidence that victims were unlikely to recover anything of value. Detailing how the scheme worked, Judge Graham said Paradise's Mine and Foster, as his president, solicited unsuspecting persons to invest in a residential real estate development project purportedly located on Rumpke. This was supposed to be constructed on a 240-acre Rumpke site known as the Benjamin Lord Tract, but the trial jury found Foster had no title to this land. Investors were either invited to invest in Paradise's Mine as a business, loaning funds to its marketing and sales operation, or by purchasing options in actual lots. However, US federal prosecutors were able to convince the jury that Foster did not have good title to the real estate he was selling, and nor did he use investor funds in the manner advertised. The judge said, though Paradise's Mine's misrepresentations, the company collected approximately $8.3 million from investors. Paradise's Mine paid out approximately $280,000 in partial payments to investors. Less than 3% of the funds collected were distributed as interest payments to investors. At the time of Foster's arrest, the FBI seized the $1.1 million remaining in Paradise's Mine's bank accounts. The Foster Paradise's Mine saga again exposes how vulnerable the Bahamas' reputation as a safe, attractive investment destination is to damage from the activities of unscrupulous foreign developers seeking to make ill-gotten gains. Foster also used the power of celebrity to induce persons to invest in the scheme, a host of celebrities to induce investors to hand over their money. Among those whose names were touted as Paradise's Mine buyers were ex-NFL quarterbacks Joe Montana and Warren Moon, foreign linebacker Ray Lewis, boxer Ray Jones Jr., basketball star Clyde Drexciya, and Olympic gold medalist Carl Lewis. The Tribune revealed last year how numerous Bahamian attorneys, either as witnesses or the writers of title opinions on the island, Paradise's Mine, on the land Paradise's Mine was selling, were involved in the Foster trial. And among those called as witnesses in his defense were Philip McKinsey, managing partner at Davis & Co., the law firm of the deputy PM at that time, Kenneth Toppin, law firm of ex-FNM cabinet minister Desmond Bannister, and Ruth Bodavel. They said none of whom were involved in the Paradise's Mine affair. Those payment attorneys whose title opinions were employed as Foster's defense exhibits, suggesting that there were clean title to the property he was selling, included Thomas Evans, QC, Philip Lundy, and Wade Christie. No comments?
Wow, that's all I could say.
What to say, y'all? Next paragraph said also included Carl Bettel. But they say, they qualified it by saying there's nothing to suggest that any of these attorneys have done anything illegal in relation to the Foster Paradise's mine affair. Well, how could you be given an opinion for something that is not good title? How did they get good title? How did he get good title? You see how many people selling the same land?
Be able to pull off the scam.
Everybody is selling the same land. And I don't get it. I don't get it. So I give you that one to read also. See how diligently I worked for you all yesterday?
Yes, you did, and we appreciate it.
Yes, you did. Thank you so much.
There's a lot, Miss Archer.
But you have all weekend to absorb it.
Mhm.
That's Rumkey. There are other islands.
And for such a small island, there's not a lot going on.
Everybody owns it. Okay, so
Wow.
let's go to stamp exemption. Leave that alone. You can think of that. And try to figure out what's happening. Stamp exemption. So under the Stamp Amendment Act 2008, application for exemption from stamp duty on the acquisition and mortgage of property may be made for first-time owners for homes valued at $500,000 or less. It would also be subject to VAT, but of course you could receive a partial or full exemption, and it depends on different values. So after stamping, the title document is sent for recording at the Registry of Deeds and Documents, and that's for a nominal fee. It really is a nominal fee. The only thing is that it just takes long. In 2010, the amendment brought out several changes with regard to stamping documents. So under the act, the applicable stamp duty will be the stamp duty that is enforced at the date the documents or the transactions are presented for stamping, and rather than the date when the transaction was completed or the document was drafted. Stamp duty will now be paid on the greater amount of the purchase price or market value of the property, as evidenced by an appraisal by an approved appraiser. And not just the purchase price, but consideration mentioned on the document. So the Amendment Act extends the definition of mortgage to include any promissory note made supplemental to or in connection with any mortgage or charge. So stamp duty is also required to be paid on the combined consideration when there are property transactions involving a transfer of land and a construction contract. Transfers of land to an individual, to a company, and those shares are going to be beneficially owned by that same person, that transfer is exempt from stamp duty. And the same thing if it was going from that individual to their family members, that's exempt. So under the Stamp Act 2016, the treasurer may stamp any unstamped or insufficiently stamped instrument after its execution, provided payment of the unpaid stamp duty and a surcharge of 10%. And that's where 6 months or more has elapsed from the date of execution of the document. The 2016 amendment also allows the treasurer to take into consideration the value of any adjoining property to a property in dispute as to its value. So, you know, normally when an appraiser comes, he would look at your home, but he'd also look at the buildings that are behind and on the side or in the front in order to give the full valuation of your property. So the treasurer can also do the same thing. If you have an adjoining property and they're in dispute as the actual or the true value of your property. It has to be sold within the preceding 12 months in determining the liability for the payment of stamp duty of the disputed property. The 2018 amendment levies a 2.5 stamp duty on the value of a deed of conveyance, assignment, or transfer of real property of $100,000 and under, and 10% of the value in excess of $100,000. Additionally, stamp duty of 2.5% of the value of the interest in real property is levied on a transaction or instrument which is treated as a transfer of land and which has the effect of transferring an interest in real property by virtue of the transfer of issued shares or transfer of beneficial ownership or interest of a company, and it owns property in the Bahamas. Stamp duty of $10 is payable if, of course, you have a correction that needs to be made, and that's called a deed of rectification, or what they call a confirmatory conveyance. It's a $10 stamp duty. Where there's a transfer of a mortgage and further advances are made by a new licensed lending institution, stamp duty is only payable in the further sum advanced by the new licensed lending institution. Where there is a transfer of a mortgage, the instrument evidencing the satisfaction of the subsisting mortgage and creation of a new mortgage is exempt from payment of stamp duty. But of course, referring to the same property. Under the Stamp Act, the treasurer may stamp an application for the exemption of stamp duty on any instrument made pursuant to the Stamp Act. And where approval of the exemption has been made previously, and where the title document to which the application refers remains unstamped, subject, of course, to payment of the surcharge and evidence that approval for the exemption had previously been granted. Now, so you know you have to pay legal fees, you know you have to pay stamp duty, you have to pay your outgoings, that's utilities, real property tax, then of course you have VAT. So under VAT, under the rules, VAT is imposed on any conveyance valued over 100,000, anything over 100,000, or all conveyances of 100,000 or under are exempt from VAT. So in determining the amount chargeable on conveyances for the purposes of VAT, the VAT controller can consider the purchase price and appraisal value of the subject property, and they are allowed to choose the higher value of the two. Property transactions over 100,000 now attract the same duty as stamp duty rate of 2.5% for 100,000 and under, and 10% for over 100,000. So notwithstanding the fact that the purchaser in a real estate transaction is invoiced for the payment of VAT under the VAT rules, the purchaser and the vendor may decide to split both the stamp duty and VAT 50-50, depending upon their negotiations or their agreement regarding the sale and purchase of property. Note that under the VAT rules, it allows a purchaser as a VAT registrant to claim input taxes on the supply, as long as it's in accordance with the rate on the real estate. With regard to the payment of closing costs, VAT is normally paid to the VAT controller based upon his determination of the VAT to be paid on the property transaction. The VAT controller may request that an appraisal report be submitted, and that reflects the true market value of the property. and if he is not satisfied with the consideration amount listed on the conveyance. So after the payment of VAT, the relevant stamp duty of 2.5% is paid to the public treasury, and the title documents are subsequently submitted to the Registry of Deeds and documents for stamping and recording. Under the VAT rules, VAT is charged on related professional services, and that includes your legal services, your appraisals, your title searches, and real estate commissions. First-time homeowners who are exempt from the payment of stamp duty are also exempt from the payment of VAT on property transactions. Note that the rental of residential properties and the transfer of vacant land are also exempt from the payment of VAT. So on the next page, I give you the standard fees. So for VAT, if the property is valued up to 100,000, it's 2.5%, and anything above 100,000 is 10%. The real estate agent fees, 10% of its vacant land, 6% for non-vacant land. And of course, you have the attorney fees, 2.5% for each party to the transaction. And although these fees may be negotiated with the attorney, they vary for transactions under 100,000 or over 500,000. You have the investment board fees. And then you have real property taxes, owner occupied property. The first 250 is nil. 250 to 500 is 0.625. 500 to 5 million is 1%. And over 5 million is 0.25%. And of course, you know, there are exemptions for first-time homeowners and vehement owner of vacant or non-vacant land in the Family Islands and vacant land generally. So non-vehement owned vacant land, first 7,000 is $100. 7,000 to 75,000 is 1.5%. 75,000 to half a million is 0.75, and over half a million is 2%. There's the appraisal standard fee from $350 to $500, and that depends on the scope of the appraisal and any negotiated fee. Most financial institutions and the public treasury require appraisal reports from an approved appraiser. On the case of the public treasury, an approved list from that government agency. Some financial institutions require a comparative analysis of properties which have been sold or purchased within the last 6 months to a year in the same area or location as the subject property to be mortgaged or financed within the appraisal report. The requirement may increase the standard price of any appraisal report, which is normally paid by the purchaser or the mortgagor. And then there's title search. There's a standard fee of $350. Of course, you have to add VAT. The recording fee is $4.50 per page. Now the fees for mortgages, I know each bank has its own fees. So I just did a general listing of bank service fees. It may vary. The legal fees, of course, is 2.5%. And the stamp duty, satisfaction of mortgage, and recording fee. Note that under the VAT rules, there are exemptions from VAT for certain transactions. So an inter vivos gift, you know what inter vivos means? Yes?
No, ma'am.
Okay, inter vivos means VAT. So a gift,
You blanked out, Miss Archer.
huh?
You blanked out.
Oh, I say inter vivos means a living,
On living,
while you are living.
or while you are living. Oh, okay.
Yes, inter vivo. The inter vivo's gift of real property that is held by the transferee at least 7 years from the date of the transfer. So you see what they in the VAT is the exemption has conditions. So if you have a gift, go ahead.
Is that the same thing as a deed of gift?
Yes,
Okay,
it's a deed of gift, but they made it, they given it some distinguishing factors. The deed of gift while living has to be done while the transferee and the transferor was living. It was a deed of gift, and the transferee held that property for 7 years. And where there is no change in the beneficial ownership, is exempt from VAT. If the only transferees are the transferor, so let's say I have a piece of property and then I want to transfer it to myself again, or to my spouse or my parents or my children, that's exempt from VAT. If I create a company and transferring the shares, transferring the ownership from myself to the company, and I'm going to own all the shares of that company, that is exempt. If I have a gift of property, I'm giving it to a trustee to administer, and it says where they express on unalterable terms of the trust, permanently exclude the trustee from taking or receiving any title to the trust property or income, then of course, it's VAT exempt. And you also have VAT exemption where a foundation, where the only beneficiaries are the founder or the founder's spouse, parents, children, or remoter issue. You're exempted if you have a gift of real property from a charity to another institution or body. You don't have to pay any VAT if you have a real property transfer and it's the matrimonial order. So talking about after you have a divorce and you have an ancillary order where you've made your agreement as to who is getting what property, you don't have to pay any VAT. Of course, you know, there is an exemption for the dwelling for the value, 500,000 and below. And there's an exemption when you move your mortgage from one institution to another one. And there's an exemption if there's a transmission of real property on the death or bankruptcy of the owner of the property to their personal representative or their trustee in bankruptcy. So in all of those scenarios, you're exempted from VAT. So now let's go and read our case of the treasurer and Alco Holdings and Scotiabank. Let me know when you pull it up.
I have it.
You have it? Anybody? Let me make sure. Okay, now this is another good one to read. So let me read the highlights. So in 2019, the treasurer obtained a judgment against Alco in the sum of 1.3, but I should say $1.4 million, unpaid real property taxes and surcharges associated with the properties on Elizabeth Avenue and West Bay Street. So execution on the judgment was suspended for 90 days in order to give Alco some time to submit an application in accordance with the Real Property Tax Act. So prior to the entry of the judgment in 2019, Alco had offered to convey lots numbered 18 through 23 in Sea Beach subdivision in satisfaction of the debt. You understand that?
Yes, I do.
Okay, okay, all right. Everybody
Yes, I
did.
understand.
So Alco is owned by Mr. Alfred Corley. The letter of the offer was written to Ms. Strawn, who is the acting chief valuation officer. So Mr. Colley says that the lots were offered to the government as the government had previously expressed an interest in compulsory acquiring them. You know what that means?
No, ma'am.
Yeah,
Okay.
they want to take the lots for basically, I guess, little or nothing.
No.
and Use
Oh,
it
no.
for something.
No, it's market value.
Yeah, but
Market
their
value.
market value is usually little or nothing.
Yeah, the market value. So the same way where we discussed the Quieting of Titles Act, where you can seek adverse possession by planting or putting a fence on a land. As I said, you only have an interest in land. The land is actually owned by the Crown. And so under the Acquisition of Land Act, the government can come and say, I want this piece of land to do whatever it is, widen the road, build a bridge, whatever. So they have the authority to do that. So he said that the government had an interest in it. And so he is offering these plots of land that he owns to real property tax treasurer. So it was confirmed that the government was interested in it. Because he also had a meeting with the Prime Minister on it. The government had commenced construction of seawalls on the Sea Beach property with Mr. Colley's consent. The offer was ultimately rejected, notwithstanding a somewhat favorable meeting with the Prime Minister. So he made two payments, 700,000 and 35,000 on the West Bay Street property with the Department of Inland Revenue in May 2021. The payment, he said, was as a result of the acceptance of one of two settlement options offered to it by staff at the Department of Inland Revenue. And he says that when he made those payments, according to what he had discussed and agreed with the staff, say that was full and final settlement of all the amounts that he owed the Department of Inland Revenue. And they said if it was paid by the 31st of May. So ALCO said that when the Department of Inland Revenue said that, he said to him that was an offer. And in support of that, he produced this calculation worksheet. So the treasurer says that what ALCO calls an offer to settle was nothing more than a calculation worksheet, which is provided to every customer making inquiries in connection with making payments pursuant to the Real Property Tax Amnesty Order 2021. The treasurer suggests that ALCO, I always can't say this word, surreptitiously sought to take advantage of the amnesty order, notwithstanding the benefit of the order could not apply to its case. Under the amnesty order, property owners were forgiven half of the outstanding real property taxes if paid prior to the 31st of May, 2021. They point out that Colley went directly to Inland Revenue staff rather than to Ms. Strawn, the Chief Valuation Officer, as he had done in 2019. Additionally, Colley did not correspond through his lawyers, Roland Roll, or the treasurer's lawyers. They also say that when Colley was asked to contact Inland Revenue concerning his attempt to benefit from the amnesty order, he did not make contact with them. What you see happening here before you turn the page? What Colley doing?
To me, I think he's just trying to be evasive and trying to see if he can get out of paying this outstanding real property tax.
But see, he's mixing up oranges. He has a lawyer. He should have consulted his lawyer because he has a judgment death over his head.
Mhm.
It's a judgment.
Okay. Mhm.
So the treasurer's case is that since April 2019, he had an outstanding debt, a judgment debt. And that was owed to the treasury by Alco. So they said that Alco has not appealed the entry of judgment. He didn't appeal it. He got a judgment order, he didn't appeal it. And he didn't apply to the court that the judgment set aside. So he just totally, he believed he slipped. He just totally ignored the judgment and decided to go in a roundabout way. So instead, after making the recent payments, it has confirmed that it will not pay the full amount of the outstanding judgment debt. The treasurer says that it is entitled to sell Alco's property to ensure that it is not deprived of the fruits of the judgment. So Alco
Ms.
case,
Archer,
go ahead.
sorry to interrupt, but
No, go ahead.
generally when there's a judgment, isn't it that usually they don't accept partial payment, like they would only accept whatever is the total amount of the judgment and settle it? Because usually once a judgment starts, it's like they accept all partial payments, because even in foreclosures, that's what's done.
Yes. but
Why
that's
would they
how-
accept part of the money and not all of the money?
Okay. I could give you a good example of this. When I went to the Department of Inland Revenue with my brother on his properties, and then I read about the amnesty in the paper, he forgot. When I went to real property tax, I asked them about it, and they said it was still in effect and it was finishing on that Monday, and we were there on that Thursday. And so I call him and I say, run and come, because you don't want to wait till Friday or Monday. The line's going to be too long. So when he went there, he had his old numbers. And the same way you see this calculation worksheet, you go to the desk and they'll do a calculation for you. They'll ask you, are you trying to get the amnesty? And then they'll put it in the system and they'll tell you how much you owe and where the amnesty applies. He was slick. He knew he had a judgment order against him. The judgment order is for 1.4 million. But he decided he had amnesty, he's going to go for the amnesty. How can he be getting amnesty on that, on a judgment? How is that possible? How did he figure he could give them $700,000 against a $1.4 million debt to the government?
I mean, Ms. Archer with that too, I do understand he is wrong with that because, you know, there is a court judgment which would overrule anything else. But negligence on inland revenue as well, because they shouldn't
No,
have quoted
Petronia.
him amount.
No, what I'm telling you is when you go there to pay the real property tax, those persons out front who prepared this thing, they're junior staff. He knew he had a judgment order. He knew he should have gone to the treasurer.
No, Ms. Archer. That's like if you go to the bank and if you say, you know, your property in foreclosure or, you know, in some form of arrest and they take an action and then you go to the bank and say, hey, how much I have to pay? And they take that payment. As far as you're concerned, I pay what you also have to pay. Like you expect you know, the same organization to be on the same page.
I agree with you, but something's above certain people's head.
Yeah.
But he knew what he was doing. He ain't down.
I would
Yeah,
think though, with junior staff, if they see someone coming in to make a payment of that magnitude, that they would consult their manager or some other senior person
Let's just take,
before, you know, just acting
yeah.
as though it's just a normal transaction.
As a matter of fact, we were there all day. And besides the 2 to 3 little girls we see going back and forth, I didn't see one supervisor. No one in authority. Came out and asked nobody nothing. And that could be where it is. You can't sit in your office if you have lines of people inside and towing lines outside in the hot sun. But on that day I was there was no supervisor. So Alco is saying to the court now that he doesn't owe the treasury any money on the West Bay Street property because he already paid that off in full. So he's asking the court to everything that's a judgment against him, get rid of that. And the treasurer can't ask about the offer for the land that he had offered because that's off the table too. And he says that the treasurer, going back to the part that Chris said, he's saying that the treasurer is bound by the actions of their staff. And then he said that he had a legitimate expectation that the offer was to be honored. So he's saying he made an offer and the offer was in line with the discussions that he had with the prime minister. And so he already had that expectation that the government was going to move ahead with that deal. So the judge says, I am not satisfied that any settlement offer was made to Alco by the treasurer. Because you have to understand, when he talk about that settlement offer, in law, you now move from, let me remember when I started, I spoke about an agreement for sale, or what you call a contract. When two persons wish to enter into a contract, the first thing you have to do is to make an offer. And in law, you either actually make an offer or you make an invitation to treat. An invitation to treat means I'm just letting you know what I have. This is what I'm offering you. If you're interested in it, come back and let me actually make an offer to you, a firm offer. So the judge is saying that there was no firm offer made to the government at all. To him, it was just an invitation to treat, like, let's start the conversation. So firstly, the judge said it's unbelievable that Alco, being engaged in contentious litigation with an approaching court date for enforcement against it, would be engaging a staffer at the office, negotiating a compromise for the settlement of the judgment. Because whatever he pay has to be against the judgment. It's not going towards no amnesty. It's going against the judgment. And this at a time when it, as well as their opponent, are represented by seasoned and experienced counsel. So another thing you have to remember, once you have a counsel on record, according to the courts, that is the route that you go from and to, is through your counsel. So second point, he said, putting aside the real estate issues of ostensible authority which arise, which means that was Mr. Thingham himself, did he have the authority, Mr. Cawley, did he have the authority to speak on behalf of Alco Holdings and bind that company? So he said, putting aside the real issues of ostensible authority which arise, what was presented was clearly an inquiry relative to the amnesty order and not any options to settle the judgment as Alco and Cawley contends. This is reflected by the fact that the terms of the offer clearly relate to the rebate under the amnesty order for the West Bay Street property. The document speaks to paying outstanding taxes up to 2021. When the judgment entered in 2019 does not include taxes up to 2021. And this was clearly an inquiry initiated by Alco. He says, thirdly, Cawley knew, as he is deemed to know the state of the law. Remember, ignorance is no excuse when it comes to the law. So he says, Cawley knew that the amnesty order did not relate to him. So even if he didn't know, he had counsel. So he should have gone and spoken to his counsel. Can I do this? And then it speaks to the amnesty order. It clearly provides order not applicable to 2021 tax. For the purposes of clarity, nothing in this order shall be construed to grant any waiver of the tax assessed on any property in respect of the year 2021 or reduce the amount payable under any judgment awarded by the court in proceedings under section 23 of the Real Property Tax Act. Fourthly, nowhere in the purported settlement proposal or offer is there any reference to it being in full and final settlement of the 9th of April 2019 judgment. In fact, the document is called a calculation worksheet, making it an untenable proposition that this was an offer to settle as asserted by ALCO. The judge says, fifth, besides the purported offer, not stating that it was in full and final settlement of the judgment, nothing in the purported proposal or offer relates to the Elizabeth Avenue property. This reflects ALCO's complete awareness that this was no proposal or offer for full and final settlement of the April 2019 judgment. In its submissions, ALCO accepts that the Elizabeth Avenue taxes have not been paid, as it alleges that there are discrepancies concerning this property, which remain to be resolved. This is important because it has to be borne in mind that the judgment was made up of a composite of the understanding taxes for the outstanding taxes for the West Bay Street property, as well as the Elizabeth Avenue property. In the absence of an agreement or representation by the treasurer, which I am satisfied did not exist, the issues of estoppel and legitimate expectation do not arise. So then he went on, he says, I'm satisfied that the treasurer is entitled to an order for the sale of ALCO's property. And then he gave you the section under the Supreme Court Act in the next 2 pages. And so he says that when that judgment was placed by the court, paragraph 16, it created an equitable charge on the land that is owned by the judgment debtor in favor of the judgment creditor. So you see how the treasurer's interest arose? When the judgment was given, it gave him an equitable charge on the land that was owned by ALCO. And so the judge said, I order that should ALCO fail to pay the judgment sum of $734,000 with interest at 6.25% within 60 days, the West Bay Street property shall be sold, and the proceeds of the sale will be used to settle the outstanding judgment debt and interest. Should the property have to be sold, it should be appraised by a reputable appraiser approved by the court and listed with a reputable realtor approved by the court. I'm satisfied that the order should relate only to the West Bay Street property, subject to these parameters. Subject to these parameters, the treasurer shall have conduct of the sale. He lost the case. Any comments?
I feel for ALCO, man. I feel for ALCO.
You feel for them?
Mhm.
You, what side you trying to take?
I mean, I guess the only thing that I feel like give the treasurer a leg to stand on in this one was there already was a court judgment, right? So
Yes.
if he didn't pay and 2021 came around and there wasn't no judgment at that point in time, the amnesty would have been, I guess, applicable to his particular case. I guess so that's one thing. And then my other challenge with it is with the whole arrangement for the, what do they call it again? When the government wanted to take possession of the Sea Beach properties, he didn't have a proper arrangement with the government there. But part of the case also notes that the government did start doing construction of the seawall on those property. And I remember going way back to like basic contract law, even in absence of actual physical contract, we agreed to something and they started initiating on that process. But that would be, I guess, a separate suit against, I don't know, the government or Ministry of Works rather than the treasurer. But, all are still relations with the government. So I feel he's still, they start billing on the property. They take my $700,000. And at the end of the day, I still fall with nothing. So I feel for him a little bit. He was wrong, but I feel for him a little bit.
Why you feel for him? He knew he owed the government 1.4 million.
Yeah.
He really, truly believed as a businessman that the government is going to just write off $700,000.
I
Seriously?
mean, well, I think they would have done it for others, right?
I don't know about that.
Well, the thing
can't
is, even in a situation where, for instance, if you're in a banking situation with a mortgage and you have failed to pay and you're going, about to go into foreclosure, and you come into the bank and you entertain talks and say, listen, can I make some other arrangements? And they agree, well, okay, you can't pay the full amount. We'll agree to restructure things for you and you'll pay a lesser amount, but you have to continue to pay timely, until whatever amount is paid off, or we'll write off a certain amount. But all of that is always put in writing once that verbal agreement has come about, and it's set in writing and clear cut so that all parties understand clearly what the agreement is. So even when he spoke to, members of the government and had conversations, what should have happened was that they should have documented those conversations and then, directed it to whichever departments or persons when needed to be, privy to that information so that they would know what was agreed and what was put in place.
I agree with you. Because but I get Chris Pad when he started talking about, they had the agreement and he started to do down the walls. Yeah, blah, blah, blah. But he was still trying to be slick. Because why didn't he go through his attorneys?
I think there was a little slickness on both sides, to be honest, because if they started doing the walls, but they didn't properly document everything for that transaction, they were also negligent on their side of it too. And that probably gave that little gray area of wiggle room that was being used by both sides.
Because as a government, how you start the work, and then you could talk about, the offer was ultimately rejected. You didn't start the work on my property. What you mean rejected?
Well, okay.
We should have gotten it in writing.
Look at the disconnection now. He had a judgment order against him from the Department of Inland Revenue, but he was having discussions with the Prime Minister. Do you think the Prime Minister and the ministry spoke with the Treasurer of Inland Revenue?
First of all, the Prime Minister shouldn't have been involved. That's not his personal situation. Shouldn't that situation go through lawyers also? Why is he involved?
Okay. But that's part of the problem in the country too, Ms. Archer, because it's just, the way that the government goes about their business a lot of time creates these issues and challenges.
And that's a separate issue.
Yeah, because another how come Inland Revenue allowed him to not pay taxes on his property for such a long time? That he owes 1.5 million, so he never paid his property taxes?
Probably not.
It's crazy.
But you may be surprised how many there are like that.
So I try to know about the AML, man. How they take this? How they take this $800,000? How you think Inland Revenue take that? You think they get any source of funds for that?
Oh, that's different. Listen, I did not even think of that when I was reading. I did not even think of that because, like you were saying, they're trying to figure out where he was confined. Like when you say where he could find 1.5 million, so that's why he was offering them the property. But what this man does for a living? Anybody know him?
I'm
mean, like-
assuming that that's a business of some sort and therefore his income would be produced by a business.
Maybe he has some other kind of business.
Well, I mean, he has a company and I'm not sure who this person really is, but
No,
I'm thinking I know who it is, but I'm assuming that his income would have been coming from his business ventures.
I remember when the story hit the papers, this,
Bill?
how it
I
have in
don't-
the assessment worksheet, this, nightclub, this was, I guess what the zoo used to be, across from Sanders Beach.
I know, I knew that name.
Right,
Yeah.
yeah, that's what I thought it was too.
Yeah, okay,
Which
yeah,
it makes it even more funny from a, from an AML perspective, because
yes,
your
yes.
business used to be cash intensive anyhow, so who knows really what's going on here with your actual wealth.
I wonder how they, well, hold on now. We do have the banks in class. So you probably took it from one of his accounts.
Yeah, I can't foresee him like walking into, inland revenue with bags of cash.
No, not that amount, but I can tell you people who came there to pay 10,000, 25,000, 30,000, they brought that in cash.
Which doesn't make any sense. That makes you suspicious. Why are you fucking around with that kind of cash?
They did.
Well, right, when you think of the recent pandemic, a lot of persons, I mean, honestly, the banking situation is very horrible. So to even stand online, to go inside, to have a transaction done, it's like crazy.
Yeah, and I think a lot
So
of
a lot
them-
of persons also realized after the pandemic that they weren't able to access their monies to other means, so they had to have cash on hand.
Mhm.
That's a lot of cash on hand though. And even if you bring that cash on hand, you have to have some kind of backup to say where that cash comes from. You have to bring a statement to the bank to say, well, this cash was gathered, or this cash was a gift, or I've been saving this cash for 3 to 4 months out of my salary. Something has to play when it comes to source of declaration.
Yeah,
Well, you
but
know
in
what-
his case, he has lots of business ventures. That one venue was not his only business source of income.
Right.
Mm,
And so if each one of his business ventures are held by companies, he can just intercompany loans
Yeah.
or
You
from
can
one
do a manager's check.
that account. It can be done.
More than likely, that's exactly what he did. He wouldn't
Yeah.
have walked in there with cash. He would have had some sort of a manager's check.
Right.
I'm
so
sure they probably don't accept personal checks there anyway. So,
No.
I mean, I don't know because I haven't been there recently, but I'm sure he had the proper instrument in order to pay them.
yeah. So he would have just moved money around. That's what he probably would have done. I know y'all would have loved that. All right, let me finish this chapter because you all are too excited. Oh, one more I want to read before I do Lisa's. The next one is the Sandra Camp and Mamlaka Limited. So this question in this case was about whether Dawa had been abolished by the Inheritance Act of 2002. I know you heard people talking about this Dawa. When you have a husband and wife who own a piece of property. Yes or no? It's
Yes,
normally
I've heard of it.
they talk about the wife has to renounce her Dawa. So if you look at the italics, it says a paragraph 2. There does not appear to be a ruling by the court on this point so far. However, by letter to the Honorary Secretary of the Bahamas Bar Association, dated the 15th of July, 2003, His Lordship, the Honorable Sir Burton P.C. Hall, Chief Justice, informed members of the bar of his intention to continue the practice of signing commissions as follows. commissions to take renunciation of dower. Since the enactment of the Inheritance Act 2002, there has been uncertainty as to whether renunciations of dower were still necessary in respect of conveyance of real property, and consequently, if it was still required that the Chief Justice issue commissions to take renunciations from wives resident without the jurisdiction. Kindly inform members of the bar that the office of the Chief Justice, having taken advice, will govern its practice according to the understanding that at common law, where a woman marries and her husband owns real property, or where the husband acquires real property during the marriage, and in each case, such property may possibly be inherited by issue of the marriage, the wife becomes entitled to an immediate life interest in 1/3 of such property, which vests on the death of the husband, that is, the right to dower. While dower was abolished by Section 3 of the Inheritance Act 2002, in respect of all persons dying after the 31st of January 2002, the right to dower was saved by Section 10 of the Act to all wives who had that right up to the 31st of January 2002. This is to say, because the right to dower attaches itself to the property immediately upon marriage, or as soon as the husband acquires the property. You hear that, Chris? Thus, despite the abolition of dower, all wives who possess the right to dower prior to the 1st of February 2002, when the act came into force, retain the right by virtue of Section 10. Accordingly, this office will continue to sign such commissions when properly submitted. Of course, it is open to any attorney who have a contrary view to file suit in an appropriate case, and it will be assigned for hearing by a judge other than the Chief Justice. Signed by Sir Burton Hall. So this question was raised about dower with a vendor purchaser. Summons filed on the 1st of February 2008 under Section 4 of the Conveyancing and Law of Property Act. And it sought the following order, that the following answers to the defendant's requisition in the above sale are reasonable, satisfactory, and sufficient. A, requisition. So you know when we did the process for agreement of sale, and you're talking about whether or not the vendor has a good title and the purchaser can make requisitions. So this is say I made a requisition of dower for Karen Ruki or Rukel was never executed and or recorded by the attorneys for the plaintiffs or vendors upon purchasing said property from Gernot Rukel, the husband of Karen Rukel. Answer: that Gernot Rukel purchased said property as a bachelor from Carl G. Fisher Company Limited on the 29th day of February, 1968, and subsequently sold the property to the present plaintiffs or vendors on the 10th of February, 2003. That the dower right was abolished, therefore, the dower of Karen Rukel is of no effect. So although the legal question is not precisely drafted, in his presentation, counsel for the plaintiffs confirmed that his application was to seek the determination of the court on whether or not dower was abolished by the act. So you have an agreement for sale, and you have a question as to whether or not dower was abolished. So let me carry you down to that. To the end. So go to paragraph 32. Because what the judge did is he went through the Interpretation Act. And then the Dower Act, and then some cases. So he says here, as paragraph 32, that's page 12. He says, as renunciations of dower and commissions to take dower cannot be said to be rights or privileges acquired or accrued under Section 20 of the Interpretation Act. The effect of the repeal of the Dower Act is that they have been abolished and are of no effect after the date of commencement of the Act. I might observe that in construing the Act as a whole, that to hold otherwise than that dower has been abolished would appear to lead to an inconsistency and possible conflict in the Act as it relates to the entitlement of a child or children under Section 4 of the Act. Would the surviving spouse be entitled to 1/3 of an intestate's estate or to 1/2? The corollary would also arise. Would the child or children be entitled to 2/3 of the estate or only 1/2? Parliament is presumed to legislate to avoid repugnancy and inconsistency. And for the reasons outlined, I rule that dower was abolished by Section 3 of the Act. Accordingly, with the repeal of the whole of the Dower Act by Section 29 of the Act, the provisions relating to renunciation of dower and commissions to take renunciations of dower have always been repealed and no longer have any effect. Transfer of existing rights of dower must be conveyed in the usual form that such interests in real property are conveyed. I further rule that Section 10 of this Act is declarative of the general law and rights of dower, save thereby refers to rights acquired within the meaning of Section 20, subsection C of the Interpretation Act. In this case, it means right of dower, endowable property, of which husbands died solely seized prior to the commencement of the Act. So he says, finally, as in so longer, by virtue of the provisions in Section 20, subsection E of the Interpretation Act, the remedy to enforce those rights acquired by enforcement proceedings set forth in the Assignment of Dower Act continue to be in effect, notwithstanding that the two Dower Acts have been repealed. So what did the judge say? Do we still have the renounced dower?
What does, yeah, maybe I'm not sure what this saying. What was the judgment from the judge that they still remain to have interest even though that the act was repealed? Is that what's being said?
If that right of dower was in effect when the husband died.
Oh, when they died, okay.
Yeah, that's sort of, it had to be prior to the commencement of the Act. Remember, the Act came into force the 1st of February 2002. So anyone who died after that, any husband who died after that, there's no right of dower.
Right.
But prior to, that right of dower would have still been in effect because the saving clause, you notice whenever you read a legislation, when you get near to the end, they have a savings clause.
Right.
Never know that?
Right.
Yeah, so that saving clause, even though they're gonna tell you they repeal a whole act or they replace and repeal, what it's saying is that any actions that were done in that old legislation is still legal. That's what a saving clause means. Because you have to do a catch-all. Especially if the new act speaks to different obligations or different requirements. So you have to have a saving clause because they could contradict one another. But see what he said here? Parliament is presumed to legislate to avoid repugnancy and inconsistency. So that's renunciation of dower. I giving you a plenty today, hey.
How do you feel about the Dower Act? Did you feel like it was something that was reasonable and fair? Or did you feel that it should be abolished?
Well, see, don't forget now, with the abolition of dower, we had the New Inheritance Act. So with the Inheritance Act, if your spouse died, remember what I said in last class, and you had no children, you die without a will, you inherit the full thing. It's yours. And that's what the judge was saying. If the right of dower is still in existence now, and you have a wife and you have children, so what does that mean? Are you taking a part of what is entitled to the children?
Are children really actually entitled though?
They get.
I'm sorry. I mean, I'm saying this. I have children myself, but I'm just, throwing it out there. Should they just be entitled just because they're your children?
Yes.
Like,
yeah, by law they are
some
required.
children don't deserve to inherit anything from you.
Then you write a will.
So actually with the this Dower Act, this one a little bit before me. Was this just for just rules of intestacy? Like this was just in the event that there isn't a will, or was that even to override the cases when there are a will or some other agreement?
This was even when the wife had that right by marriage. And so if you were going to the bank to mortgage a piece of property, the wife had to come in and actually have the lawyer prepare a renunciation of dower, which means she's letting go her interest in the property.
What was the origination of the dower? Is this back in the, old days when, Chris, like if you went to go and marry someone, right? The father would pay you some money and give you all sorts of stuff, because you're taking the daughter and you're into marriage. Is that the reason behind the dower, Ms. Archer? Because I would assume this dower situation started from centuries ago.
Well, I don't know if it's centuries ago, but I mean, it gave you a right. Think about women in the old days. If I am going to marry, right? You go into a marriage, in most instances, you come in with nothing. And so you get some ownership in your husband.
And also the women usually didn't work too. So they took care of the home, they took care of the children. They didn't get paid, they didn't get a salary. So I could see where that would be important. And I think the whole thing with a man not being able to mortgage off the house or the property without his wife knowing is actually a good thing, because I know somebody in today's world that happened to, where the house went in foreclosure and the wife and the children were living right there. And because everything was in the husband's name, she had no clue what was going on until the house is literally they were being told to, to vacate.
Mm-hmm. Yeah, so by having the dower, the wife more or less have an entitlement to what you call a life interest in the property, which means she cannot be moved. And that life interest that she has vests once he dies. That's the right to dawah. So that no longer exists. What they say is you die without a will, by law, no children, you get all. If you have children, you get 50%. So that 1/3 isn't there anymore. So I thought I put that there for dawah. Because you may have an issue when it comes to a mortgage and someone's saying they need dawah. So it depends on when the person died. The husband died. If it's prior to 2002, then yes, you would need one. If not, no. Okay, now, lease. We spoke about lease last class. And we know that lease again is another contractual agreement between the landlord and the tenant. Normally when you have a lease could be for a short period or a long period. And a lease has what we call some essential characteristics in order for you to have a valid lease. So the first thing is the tenant has to have the right to exclusive possession of the premises. If the person granting the lease remains in the control of the property, then there is no tenancy. If there's no defined premises for the lease, only just a contractual obligation to provide like storage, something like you going in and out, but you actually don't have exclusive possession, that arrangement is considered just a mere license. And that's not a tenancy. A tenancy cannot be for an uncertain period. It is either monthly, yearly, weekly, but it can't be uncertain. A lease has to be created in the proper way, and it's to follow all the legal formalities. And the lease depends if you want to create a lease whereby you would have created a legal interest. It has to be drawn up in that way, in that you will have the legal interest in that lease during the duration of the contract. Now, there are different types of commercial leases. A lease can be granted for a fixed period of a certain duration, and that could be short-term or long-term. The commencement and the duration of the term of the lease it can either be certain or it could be rendered certain before the lease takes effect. And the lease for a fixed period automatically determines when the fixed period expires on the lease. A yearly tenancy is one that continues from year to year indefinitely. And of course, you know, it is terminated by notice or the death of the landlord or tenant or the assignment or interest. So normally has a provision in terms of termination, and it gives you different options as to when you can terminate a lease. Generally, a yearly tenancy may be created by implication in instances where a person occupies a premise or premises with the owner's consent and rent is charged or measured for years paid and accepted. So that's a yearly tenancy. Because you could have a tenancy where you signed a contract for 5 years, but you pay your lease on an annual basis, or you could pay your lease on a quarterly basis, or you could pay your lease on a monthly basis. Monthly, weekly, and other periodic tenancies can also be created in the same way as a yearly tenancy. And that could be by express agreement or by inferences. Because remember now, you can have an agreement whereby you have it in writing, which is express, or you can have it oral. And remember, when two persons enter into an agreement, you can actually perform that agreement just by acting. A tenancy at will, and that's where a tenant, with the consent of the landlord, occupies the premises as a tenant on terms that either party may terminate the tenancy at any time. In this situation, the landlord, he is entitled to some compensation for use and occupation of the premises. Tenancy at will terminates when either the landlord or the tenant does any act that is incongruent with the tenancy. So it's against the provisions, the obligations on either side, the duties and responsibility of either the landlord or the tenant. Or they could just give notice. The general provision of a commercial lease is you have the parties, the premises, the rent and the duration. A commercial lease should specify the rights and the duties, the responsibilities and the obligation of the landlord and tenant. And if there's subletting, then the identity of the subtenant, or at least a provision in the lease stating that the tenant is allowed to sublease. Remember I said before, if you have a lease for 10 years, you cannot sublease it for 11 years. It has to be less than the time that you've leased it for. The parties to a lease should ensure that certain provisions for repairs, insurances, indemnification, leasehold improvements, options to renew, notices and termination of the leases are explicit and discussed in detail before execution. Where there are express terms are not in the actual lease, you also have implied covenants. And implied covenants normally come from what we call common law, from case law. So in the absence of express terms and condition, or what we call the usual covenants, which means things that are related thereto, to the subject of the contract, there are implied covenants for quiet enjoyment. So whenever you enter into a lease for a fixed period, and they say that you have exclusive possession, what you're looking for is quiet enjoyment. Your landlord should not always be in and out of your property or always knocking on your door, because then he is disturbing your quiet enjoyment. And you also can sue for that. In addition to the implied covenant of quiet enjoyment, a landlord has an obligation not to derogate from his grant to the demised premises. And in some instances, he has ensured that certain premises are fit and proper and that everything is always in good repair. The tenant has an obligation to pay rent, tax rates and assessments, and not to commit waste. They have to allow the landlord to view the demised property and to make repairs in the absence of the express terms and condition. And then I just gave you the stamp duty for commercial leases. Any questions? No, yes? Falling asleep?
No, ma'am, I'm right here. I'm trying to
Okay,
absorb
so-
all this information.
Yes. So if you haven't read the cases we did tonight, read those. For next class, let me see something. Because we haven't discussed quieting. I want to do a couple quieting cases. So we're going to talk the next class about different types of mortgages. And then we're going to move into mortgagors' duties, liabilities. Okay, so I'm going to move into, okay, I'll do I'll start off by doing a quieting title. And then we'll get into mortgages, the different types of mortgages. And I'm gonna send you some cases on for chapter 3. I'll try to find some that are not too long. Now these ones, what I'm gonna send you, I'll probably send you two or three English cases. But I do have some Bahamian mortgage cases that have gone to court. But I'll send you, I'll set the ground for the common law cases, the English cases. And so you can get a feel of why the judge makes the decision that they make when you go to court. Okay, so we'll do
Okay.
Monday. We'll start off with Milton Strawn versus Harcourt Strawn. You should have that. Look in your set. That's a quieting. And then you should have one with Rodin. I saw that one already. That's also a quieting. So make sure you have that one. Milton Strawn and Harcourt Strawn. Let me know if you have it.
Yes, I do.
Okay, all right. So those two we will start off with, and then we go into the chapter. Just so we could do adverse possession and you can have an idea of what goes on in the courts for adverse possession. Okay, so if there are no questions, enjoy the rest of your week. Please read your cases. I'm not giving you too much work, right?
It's a lot, but it was very interesting.
Okay,
Very interesting and very enjoyable, at least for me.
okay. All right, so we'll do those two. That's good to hear because we have a long way to go. And you'll find out you learn much more.
So you said next class is Milton and Daniel. And who else? Rogan? Is that?
Yeah, Simon, FP, Rodin under the Quieting Titles Act. It's there, it's an email because I saw it.
Yeah, okay.
I saw that one. So those two we'll do quieting, and then I want to send you some common law cases on remedies, just so you can have an idea of how the English courts, and then I'll move from there into some Bahamian cases on more where the banks are suing
Okay.
their clients. All right. So I'll hear from you all on Monday.
Monday or Tuesday?
There's class on Monday?
Monday.
It's a holiday, right?
Monday the holiday.
Oh, it's Wednesday. It's Wednesday, right?
It's
That's right.
Tuesday.
It's Tuesday?
On the schedule, yes, it
The
has
schedule
Tuesday.
is Tuesday.
Monday is holiday.
Yeah, Tuesday and Wednesday. Tuesday and Wednesday.
Oh.
I wrote it with Miguel and I already forgot. Yes, Tuesday and Wednesday. So I'll try and send some stuff to you, not over the holiday. And well, I'll send over the holiday, but I'll send some before that.
Okay.
Okay, so you can get started. You can get started on two, and you can make a note side if you have any questions. Okay.
Okay.
All right. So have a great
Bye,
evening.
everyone.
All right, good night.
Thank
night.
you. Good night.
Good night. On Tuesday.